There's a new Kevin Fritz letter on the Jones v. Abel docket, and it's about everyone's Roman Empire, Vanzan Inc. If you're not familiar with Vanzan Inc., then I recommend you over to my friend Katie and Casey's page. She does a very, very detailed run through of that. Go find that, go watch that. But for those of you that are tuning in, high level, Vanzan Inc. is a non-party to any of these lawsuits. It was a organization that filed a lawsuit in New York State Court under which a subpoena was issued to Stephanie Jones seeking records of Jen Abel and what happened on the set of It Ends With Us. And this letter just elucidates a little bit of what that subpoena was requesting. So remember, Vanzan sued Doe defendants for contractual tort type claims. So nothing to do with the claims that Lively now has against the Wayfarer Parties. But we now learned that the subpoena sought documents pertaining to the film It Ends With Us, Lively, Mr. Reynolds, and sexual harassment and retaliation in connection to the production of the film, none of which were referred to that Doe defendant lawsuit that was filed. So the lawsuit that was filed against Doe defendants obtaining information, the subpoena, they don't match, which is clear that what we've been saying all along, that lawsuit was an improper mechanism to seek discovery for another purpose. I think this is the first that we're hearing about exactly what was sought in that subpoena, because I don't think the public has seen a copy of that subpoena yet. So this letter is now kind of elucidating what that subpoena was even looking for. In any case, in June, the Wayfarer Parties sought to compel documents from the non-party Vanzan Inc. It was opposed, and the judge issued an order on July 7th saying, actually, you do need to hand over the documents that were requested. And with respect to communications between Vanzan and its counsel, and Jones Works and their counsel concerning the Vanzan lawsuit, the court held that it is likely to bear or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Vanzan and to Lively. Remember, while we know that Reynolds or Lively, I don't even know at this point who owns Vanzan, at that point in time, Stephanie Jones did not have a relationship with Vanzan, and certainly Wayfarer didn't have a relationship with Vanzan. So it begs the question, why was information being obtained by this third party and handed over through Stephanie Jones, the former publicist? So presumably Vanzan handed those documents over pursuant to court order, and now Wayfarer Parties have issued a deposition subpoena. So they have issued a very specific type of deposition subpoena that you can issue against an organization, a company. And that is a person most knowledgeable or corporate representative type of deposition. That's where you list out a series of topics that you want to talk to them about, and you ask the company to produce someone to be deposed that can speak most knowledgeably about those topics. So, for example, if somebody is suing Coca-Cola, I'm just making up a random thing, but if someone is suing Coca-Cola and it has to do with not necessarily their recipe or what have you, but an incident at the factory, one of the topics could be, we need to have someone that's most knowledgeable about the policies that are, implicate that particular factory. And so Coca-Cola would then have to produce someone that would be knowledgeable enough about the policies, like maybe an HR person, maybe somebody a little bit more higher up that has some awareness about the policies or understanding and does it in their day-to-day work. So that's what a corporate representative does in these types of depositions. They can educate themselves to a degree to understand and become the person most knowledgeable about those topics. So here, Vanzan is saying, well, we will produce a person most knowledgeable on the topics, except they have a discrepancy about the date. and they will not produce someone that will speak about anything that happened before September 27th, 2024. September 27th, 2024 is when the Vanzan lawsuit was filed in New York. So they're saying we're only going to produce someone to talk about what happened after the filing of the lawsuit, not about anything that happened before. And here the Wayfarer Parties are saying, what happened before the filing of that lawsuit is directly relevant to the claims and defenses here. I did clock that Fritz is potentially taking a page out of the judge's hints in his orders to show your work. And so here he goes through and talks about why there's no undue burden imposed on Vanzan, why this information is not available through other means, how long they've had this deposition notice, how much time. Typically you give 2 weeks for a corporate representative. Here they've given more time and asked for the court to compel that given all of the factors. Now, originally, the topics that they had, they set the relevant time period to be January 1st, 2022 to present. And in the letter, they're saying if that seems overbroad, the Wayfarer Parties are willing to narrow it down to July 2024 through the present. Actually, I don't even think it's through the present. It was July 1st through December 31st, 2024. So they've provided a narrow time frame by which the relevant topics would be discussed. And those topics are Lively's direct or indirect ownership interest in that organization, just the ownership interest in general, the structure, managerial structure, who makes decisions in that organization, the claims related to that lawsuit, that Doe lawsuit that was withdrawn, the relationship and communications with Jones Works, and sort of any communications with Lively relating to that subpoena between Vanzan and Lively. So communications about that. So they're asking someone to come and give a deposition testimony about what kind of communications they had with Lively about all of this. Interestingly, when you look at the objections that Vanzan filed to the deposition subpoena, they say that non-party Vanzan produced thousands of documents in July 2025. Thousands! How could a lawsuit that never even made it to a assignment to a judge, that was yanked off of the docket after 5 seconds, have thousands of pages related to it? The question here for the judge is going to be, can Vanzan hide behind a privilege? And I think he's already answered that in his July 7th order. And so they're going to need to bring someone up to speed, because I can't see how they get out of this one. I really wish I could be a fly on the wall on this deposition. Because who's it going to be? Isn't it just Ryan Reynolds and Blake Lively that own this thing? They probably don't have any employees. So is it going to be Ryan Reynolds that sits for this deposition? That is going to be wild. That is going to be wild. I'm sure we'll get a spicy opposition tomorrow. Stay tuned.